Welcome back to Checkpoint. The dramatic arrest and arraignment of Deputy Chief Justice Philomena Mwilu left legal minds divided on two main issues. One, whether the Director of Public Prosecution was interfering with the independence of the judiciary. And two, whether they violated the constitutional requirement on the removal of a Supreme Court judge. On House of Cards tonight, our senior political reporter, Chris Thairu, interrogates the assumed undercurrents of political influence in this matter.
Achukue mzigo wake peke yake. Kila mtu achukue mzigo wake peke yake. Haja yetu ni maisha ya wananchi milioni 45 karibu sasa.
That statement by the head of state came after the unprecedented arrest and arraignment in court of Deputy Chief Justice Philomena Mwilu. This after she signed an affidavit claiming that there is a plot to remove her from office since she was among the judges who nullified President Kenyatta's win in last year's elections.
We have a problem with our judiciary, but regardless, we respect, but we shall revisit. We shall respect, but we shall revisit this agenda.
And it is that statement by the president last year that has sparked debate among the political class and even legal minds that there could be a wider scheme to these latest developments. Questions have been raised about Mwilu's vetting and subsequent approval by the National Assembly for the Deputy Chief Justice position in 2016. She duly received clearance from the KRA, EACC, the DCI, and other relevant government institutions.
Many people will agree with me that DCJ Mwilu played a very prominent role. I mean, this thing was live on all television stations, and people saw that she demonstrated a very clear appreciation of the petitioner's case and the law.
When you revised the pronouncement by His Excellency the President about we shall revisit, then you can just see where the direction of this arrest is coming from.
Wewe ni nani? Wewe unajua nani? Wewe ni ofisa wa cheo gani? Please, usiseme ni Uhuru amekuchukua. Mimi sichukui mtu. Mimi nasoma kwa magazeti kama nyinyi wale ambao wamechukuliwa. Hakuna haja ya kuleta siasa hapa. Kuna siasa hapa? Kuna siasa hapa jameni.
Mwilu will go down in history as the first Deputy Chief Justice in the country to be arrested and arraigned in court. And now debate rages on the process adopted by the DPP in what is largely viewed as the beginning of the removal of a judge of the Supreme Court, which is however prescribed in the Constitution as being processed through a tribunal.
When you prosecute a sitting judge, and especially somebody of the stature of a judge of the Supreme Court and a Deputy Chief Justice no less, then indeed it is the entire institution that is on trial. We would have preferred to see a situation whereby the DCI and the DPP, the ODPP, present whatever material it is that they have through the Judicial Service Commission first, and then immediately the Judicial Service Commission find that there is need to set up a tribunal, that judge stands suspended.
The other forces that are driving the DPP, this is not him. It is somebody else who is saying, go for so and so. Now who is the next? They want now, because we have been talking about big fish, small fish, now they are just going to arrest somebody whom they think maybe is not in the line of the power to be.
DPP Nordin Haji has already taken issue with the legal representation in the Mwilu case. The team includes 4 senators and several MPs, among her 41 lawyers. Most of these were also in the defense of the NASA presidential petition.
Kama itapatikana ya kwamba Deputy CJ ako na hiyo shida, bas petition italetwa hapa parliament. Orengo atakuwa one of the senators to debate on the conduct of the CJ, Deputy CJ. Sasa nataka kumuuliza, ukiwa sasa senator, where do you draw the line?
should this matter come for any committee, especially the Legal and Justice Committee, then the members who are lawyers sitting in his case, who will happen to be now the members of also the same committee, will be required by the standing order to declare the interest by virtue of representing the same person in court.
When you are in court, you only represent your client's interests. It is not your position. But when it comes to Parliament, it's your view as a legislator based on the report that will now come before you.
Chief Justice David Maraga is set to retire on the 12th January 2021 upon the attainment of 70 years as stipulated in the Constitution, and the DCJ, Philomena Mwilu, will take over in an acting capacity until the country gets another substantive Chief Justice. There have been claims that a section of political class is keen to lock her out of that position.
Even if there was content in these criminal proceedings right now, then one wonders the timing. It becomes unfortunate, particularly when it's expected the Chief Justice will be retiring before the next election.
But because of her independent mind, some people might be very uncomfortable with her taking the position of the CJ. And you realize that sometimes, in many cases, the executive would like to control all arms of government. They want to control the judiciary, they want to control the legislature.
It's the public perception that Mwilu is pro-nas. It's just a perception, it's not a reality.
Both the defense and prosecution teams continue preparing for another court battle and locking horns on October 9th when the matter will be mentioned in court. It will be keen to watch whether this will affect the relationship between the executive and the judiciary and what holds for Mwilu in the case. Chris Dairo, KTN News.
So that arrest and arraignment of the Deputy Chief Justice in a magistrate court, a big story throughout last week. A lot of opinions on that. Tonight, we want to hear from a member of the Judicial Service Commission. This is the umbrella body in Kenya's judiciary, or parent body, if you like. Professor Tom Ojenda, Senior Counsel, JSC member, thank you so much for making time for Checkpoint tonight. You've had the sentiments by the various players, whether it be lawyers, the politicians. Professor, what do you make of that arrest and arraignment last week?
Sophia, thank you for that question. Let me say that the arrest, the Deputy Chief Justice, Philomena Mwilu, and her arraignment in court was not only unprecedented, but came as a shock to the Judicial Service Commission. I remember that morning, the DPP and the DCI came to the Supreme Court, and we had a full JSC meeting. And
who was present?
The entire commission was present. We had the 6 commissioners present. The commission meeting was chaired by the Chief Justice. They then sought to see the Chief Justice and the Deputy Chief Justice. And of course, at the time, we knew that the meeting that would ensue was a meeting that would lead to a discussion on the various questions that they had raised with the DCJ. Unbeknown to us, then an arrest would occur in the course of the day. I must say that I have never heard of arrests taking place within presence of court. And we had not before then discussed the factual underpinnings of the case touching on the DCJ.
So the DPP and DCI meet all the 6 currently in office, JSC members, then go into another meeting, DPP, DCI, CJ and DCJ.
No.
It was all of you together.
DPP and the DCI went to the lower boardroom. We were in the upper boardroom.
Right.
Then they called for the CJ, who was chairing this JSC meeting,
right,
in the upper boardroom, 74. And the intention was to discuss the matter of the DCJ, who was also in the JSC meeting.
Yes.
So then the CJ then obliged after a while and went down to meet them. These are visitors. And I think they also had the deputy to the DPP as well.
Yes.
So then they went down for the meeting. And in the meeting, the DCJ then was also requested to go down for the meeting, and they went for the meeting. But we knew that it was a formal meeting, so we had to hold on a bit. And in a while then we then learned later that they had a long session with the DCJ, and she would later be arrested. As I said, this only happens in Uganda. It's only in Uganda where I know that the Supreme Court was invaded once and an arrest made. I haven't had this in this country.
So in your view, this should have been canvassed by the Judicial Service Commission?
The issues in question, in my view, see, we have a process. We often have jurisdiction over questions touching on misconduct of judges under Article 168 of the, and often 168 sets out misconduct and other conduct that would lead to removal from office, including incompetence. We would have expected that if the nature of the complaints in question touch on performance, touch on misconduct, then that would be referred to the JSC. The only questions that we don't deal with, for instance, would be the ordinary criminal matters where there's traffic and other heavy criminal matters that we don't deal with. So we acknowledge.
This matter, yes.
But this matter is a matter, of course, I cannot go into the merits because the rule against sub judice.
Yes.
But we had expected that where it was a matter that would have involved other form of conduct other than straight criminal conduct, we would have dealt with them. But we did not have neither complaint, a reference, or any sort of knowledge, any knowledge within us at the time the arrest occurred. And the public may not know this, but we did not and had not discussed the detail of the question. No one had referred or complained about them.
But we're hearing that these matters go back to 2013. And the question has been, she was vetted. We've heard in that report by Chris Taru, usually during vetting, there will be reports from the various investigative organs. Did this matter in your knowledge come up?
I saw the charge sheet. Not as a lawyer, I'm not in that panel, but I saw the charge sheet. The charge sheet refers to 2013 and 2014. DCJ Mwilu was appointed DCJ and gazetted on 28th October 2016.
Correct.
After the public was invited to give views between the 14th to 24th of October 2016. So squarely, this matter, if it was within the knowledge of any person, would have been brought to bear in the vetting before Parliament.
So KRA did not submit anything? DCI?
As the Judicial Service Commission, we also received certain complaints.
Yes.
Which we dealt with. All complaints against any judge that was seeking a position would be heard and dealt with before the hearing. We were not seized of any of these matters. But further to that, Parliament also invited complaints. Those should have also been dealt with. These matters were not part of those things.
All right. The CJ, after this meeting with him, DCI, DPP, and the DCJ, did he speak of whether he consented or what he made of that meeting? Did he speak with you about how that meeting concluded before then we saw the DCJ escorted away?
I will tell you, we just later, in the course of the day, we just saw the news alert like everyone else. We do not know what transpired and what events led to the point at which an arrest is said to have occurred. Because I'll tell you this, we had quorum and we were conducting business until the CJ and the DCJ went for that meeting.
Okay, there's been concern around the JSC being mum on this. This is the first time we're actually hearing of those events behind the scenes before we saw the DCJ being escorted, because last year during the Supreme Court presidential election petition and those allegations around the Supreme Court Registrar Esther Nyaikai, we saw the JSC come out and write and say that if they objected pretty much to those allegations against us, saying there's a channel that needs to be followed. But on this one, we've not had anything.
You know, the JSC is made up, as I always say,
yes,
very intelligent women and men,
yes,
very considerate, very deep. And I've had murmurs about silence. The silence is because we respect the role of the DPP under Article 157.10. We know that he has the discretion to charge. We did not know what questions were there. We were not aware of the factual underpinnings of this matter before any arrest. But most importantly, once the matter went to court, it was sub judice. We can't shout about matters that are in court. But again, there's a cautionary bit that I must speak about. That it is very possible that this matter could end up on the table of the JSC under Article 168. If a petition is brought for removal, for instance, JSC or members of JSC would need to consider the facts laid before them objectively.
So even if it's going on in court, if today a Kenyan brings that petition, as JSC, you'd consider it?
In the absence of an order, the JSC would deal with a complaint brought under 168. Okay. In the absence of an order. I know that there is a petition 295 that stopped the magistrate's court from proceeding. But if a matter is brought before JSC will deal with it.
But let me then ask you this on the question of quorum, because Philomena Mwilu, DCJ, is a member of the Judicial Service Commission. I presume if the JSC was seized of this matter, should not sit in the proceedings considering her. That then would leave the JSC with 5 commissioners, which is not quorum.
I'll tell you this, and the public usually doesn't understand this, that the minimum quorum for JSC is 6 commissioners out of the 11. When there's a matter touching on the conduct of a judge, the JSC constitutes a special committee of 3 to investigate the matter.
But that decision, isn't it reached in
that
quorum?
That decision will be reached when Judge Mwilu, who is a member of JSC, who has not been removed, who has not retired, who is sitting and who is a judge, would sit in JSC. 3 commissioners, separate commissioners, would be appointed to inquire into the factual underpinnings and if there is any merit in the allegations. Under the JS Act, the report from those 3 commissioners upon inquiry would be brought back to JSC.
So let me clarify.
She would still be a member of JSC.
She'll still be. So even in decisions touching on her and the membership of this committee you're talking about, the DCJ as a member of JSC would sit in that?
For purposes of quorum, unless an individual disqualifies themselves. Remember, this is 1 commissioner out of 6 commissioners. And the decision that you are making touching on that commissioner would lead to one thing. The JSC, in the majority or in vote, because the quorum is there, referring the matter for the appointment of a tribunal. Remember, the actual action for the removal of a judge happens in a tribunal appointed by His Excellency the President, not by JSC. So that our role is merely
to investigate.
The primary investigative role that we will play as an organ set out on the Constitution. Remember also, the presumption of innocence lies in law under the Constitution. Every person, even a person charged 52, 49 years.
So you've talked about currently there are 6 members of the JSC in office. 5 are not. In terms of being sworn in, the Attorney General, the 2 representatives of the public, you also have the Justice Warsame and the nominee of the Public Service Commission. What's going on? Why haven't they been sworn in?
There were 2 petitions filed against Judge Warsame's appointment. There was another petition filed against the appointees of the President, that is the Mr. Miruri from the Public Service Commission, Professor Mugenda Olive, and Mr. Kosgei, the 2 nominees of the President.
Right.
Then, of course, there's the Attorney General, Kiara Kariuki, who is also a member of JSC, who has not sat yet, who has not attended JSC meetings.
Why?
Now, this is the point. Number 1, there's no reason as to why the Attorney General has not attended JSC meetings. There's no explanation. There's no reason.
Does he need to be sworn in? Or by virtue of his office, it's automatic?
By virtue of his office, it is not automatic because under Section 40, a member who serves in the JSC should be sworn in for the first time.
So has he?
No, he hasn't been sworn in. He needs to be sworn in. But even if he were to attend by virtue of office because he's named in the Constitution, that has not happened yet. He hasn't attended any meeting.
Right.
But let's leave that aside. The case against Judge Warsame and the 3 other members of the commission was the cases were dismissed, the petitions were dismissed, and the 4 were cleared to be in the Judicial Service Commission. The appeals that lie, but there are no orders stopping any of them from attending. What should happen, or what ought to have happened by now, is that the 4 commissioners ought to have been sworn in.
Yes. Why haven't they?
I am aware that the Chief Justice had made arrangements to swear in the 4 commissioners, save that when the Gazette appointing them came from the presidency, only 3 names appeared and Judge Wasame's name was omitted from the gazettement. So the failure to gazette Judge Wasame made it impossible for the CJ to swear in the 3 and leave out the 1. For the 1, who is Judge Wasame, represents the Court of Appeal, and the full quorum of JSC must include representation of all levels of court.
So in your view, the CJ will not swear the commissioners until the matter of Warsame justice is resolved?
No. There's a provision, Section 40 of the JS Act, which states that a repeat elected commissioner does not have to be sworn in.
Okay.
So again, in the strict sense, and because there's been a lot of misinterpretation around the law, 2 points. Judge Wasame, once elected, became a member of the commission. He should sit.
Yes.
He should sit.
So why not swear him in then?
He does not even have to be sworn in.
Okay. He's automatically a member.
He is automatically a member. Because he was required to be appointed by the president. An appointment occurs after an election. He was elected by the Court of Appeal. He was required to have been appointed 3 days after the election.
Okay.
He was not appointed by the president. It's a procedure of provision of the JS Act. But that not having happened, the court dealt with that question and held that the president ought to have appointed him within 3 days, failing which he would continue to serve as a commissioner. Remember, this is a commissioner. So then he should be sworn in? He should be sitting in, basically.
Okay. Let's move on, go back to the DCJ question, because there are 3 other judges in the past that have been charged in court. 2013, Oguk, JBM in 2008, 09, Chitembwe. In the last 2, of course, Oguk resigned later. Karaoke, Chitembwe, they sat out in the duration of their cases. In essence, they didn't preside over cases. So that with this matter for the DCJ, in your view, those who are calling for her to step aside until it's canvassed, it's brought into its logical conclusion. What do you make of that? And do you think it should be in law so as it's not left to a personal will or moral compass?
The only time that a judge steps aside from, remember those are pre-2010 cases, where a judge steps aside would be if the DCJ, a tribunal is set up, the president can suspend the judge from sitting, can be suspended. Here, as a member of the JSC, she would be suspended if a tribunal were formed. Once a tribunal is formed as a judge, she would then, there would be the option to suspend her. Now, until then, she sits and she's a judge. She continues to be a commissioner.
But the moral question of, isn't it untidy? On one hand, you're behind bars. On the other, you're behind the, you're on the bench presiding over a matter.
Let me tell you, Sophia.
Yes.
This is the sense of security of tenure.
Correct.
This is why you have constitutional office holders and others who are not. To maintain judicial independence, the Constitution recognized that there was a possibility where there would be conflict amongst the 3 arms of government, and the judiciary being the one that does not have the strength of representation, though Article 159 says judicial power is derived from the people, the judiciary is often at the receiving end of pressure from the executive and the legislature. This is traditional, it's the world over.
Okay.
And that is why judges have security of tenure. If you remove that security of tenure, and because judges rule against powerful people every day, they will not be in office. They would want to have their own people in office.
You talked about if a petition was brought to JSC, it would be considered. Can't JSC, in and of itself, of its own motion, take this matter and deal with it?
Yes, JSC can, of its own motion, under 168, deal with the matter. And that is a question that would be dealt with on the table of JSC. We have jurisdiction to deal with a matter that we learn. But remember this, we did not know of this matter until the DCJ was arrested.
So it's under consideration, perhaps?
I think that's something that the JSC will deal with.
Briefly, as our time is running out, there were numerous petitions filed against the Supreme Court justices last year in that time around the presidential election petition, including the Chief Justice himself. What's the status of those petitions in the JSC?
There are petitions that are live, that have not been heard against some judges. There are petitions that were dismissed. Now,
which ones were dismissed?
There's one thing. There are petitions that were filed and that touched on the merits of cases done by the Supreme Court on the presidential petition and on other questions. Where a petition is filed against a judge on the merits of a case, we dismiss it.
So which ones have been dismissed? Which ones have been dismissed?
The ones that have been dismissed are the ones that touched on the merits, the ones that questioned why certain decisions were arrived at.
So the CJ is dismissed?
Those are dismissed.
Which one is still outstanding?
The ones that are outstanding are the ones that touch on the conduct, any conduct other than the merits of a case.
Can you tell us which ones?
Not on the top of my head,
okay.
But I know that there are a number that are pending against some Supreme Court judges. I know there are some that are pending. But again, as I said, those are petitions brought by different individuals.
Okay.
Often, the committees consider on the merits those complaints before dismissed. They are not just dismissed like that. They are dismissed taking into account of, after weighing the substance of the claim. Let me tell you this. Judges must also be protected from interference. That is a sense of judicial independence. Where there's a threat to decisional and judicial independence, and where the JSC notes that certain complaints are made purely for purposes of threatening judges.
So do you see this as that? Do you see this as intimidation, revenge, the revisit matter by the president? Do you see it as that? Briefly, our time is up.
I'm a very fair person.
Yes.
I often give the benefit of doubt, but I also have eyes.
So the budgetary cuts and all developments, you do not see this as a revisit as some have opined? For
the budgetary cut, I would tell you this. Our budget for the judiciary stands at 0.9% of the total national budget. The world over, the fair percentage of our budget is over 2.6%. In other words, we're doing very badly. We require 1.8 billion to complete our court projects in Eldoret, in Kapsabet, in Nakuru, in Embu, and in many other towns.
So all these
we cannot undertake this because of a budget cut. We are negotiating with Parliament, and we hope that there will be a supplementary budget presented to ensure that this is dealt with, so that our projects can continue. We are losing donor support because we cannot plug in our national share.
All right.
And I think that is not fair. So I would say this, that yes, you'd read a revisit.
All right. That's a perfect point to wind up. Senior Counsel Professor
Tom
Ojenda, member of the Judicial Service Commission, with us here on Checkpoint, and we thank you for staying with us. Do not go away. We're taking a quick break. When we return, that 16% value-added tax on all petroleum products that has caused a lot of outrage. David, the economist, will be joining me in a moment. Stay with us.